Good morning. I'm Atul Chaudhary, Assistant Professor, IIMT College of Law. And for today's lecture, our topic is Principles of Environmental Law. And what are the principles of environmental law? There are certain principles in environmental law that came to us through various international agreements. So these principles are principle of precautionary principle, Polluter Pays Principle, and public trust doctrine. So these are the three principles that we will be discussing in today's video lecture. First principle is precautionary principle. Basically, precautionary principle is a rule of evidence, and particularly it deals with the burden of proof in environmental cases. This principle shifts the burden on the polluter, individual, industrialist, entrepreneur to prove that his activity, industry, process, operation is not a health hazard damaging the environment, and his action is environmentally benign. Earlier, the concept of assimilative capacity was prevailing, which was provided by Principle 6 of Stockholm Declaration of 1972, UN Conference of Human Environment. The principle of assimilative capacity assumed that science could provide policymakers with the information and means necessary to avoid encroaching upon the capacity of the environment to assimilate impact, and it is presumed that relevant technical expertise would be available when environmental harm was predicted, and there would be sufficient time to act in order to avoid such harm. Later on, precautionary principle approach was established with the 11th principle of UN General Assembly Resolution on World Charter for Nature, 1982, emphasized for precautionary principle in place of assimilative capacity principle. And ultimately, the Earth Summit Rio de Janeiro Conference of 1992 declared it in unequivocal terms. Principle 15 of the Rio Declaration on Environment and Declaration 1992 provided, in order to protect the environment, the precautionary approach shall be widely applied by states according to their capabilities. Where there are threats of serious and irreversible damage, lack of full scientific certainty shall not be used as a reason for postponing cost-effective measures to prevent environmental degradation. The basis for the emergence of principle is the non-availability of full information about the widespread ramifications, serious and irreversible harm which may be caused based on scientific experiments. This is known as inadequacy of science. It was based on the theory that it is better indeed become irreversible, and it has also based on scientific uncertainty and inadequacy of science. So we will discuss some case laws. Supreme Court of India recognized it in MC Mehta versus Union of India 1997. There are several cases of MC Mehta versus Union of India, and this is one of those several cases in which the Supreme Court talked about precautionary principle. And what Supreme Court said is that precautionary principle has been accepted as a part of the law of our land. Article 21, 47, 48A, and 51AG of the Constitution of India give a clear mandate to the state to protect and improve the environment and to safeguard the forest and wildlife of the country. It is the duty of every citizen of India to protect and improve the natural environment, including forest and wildlife, and to have compassion for living creatures. The precautionary principle makes it mandatory for the state government to anticipate, prevent, and attack the cause of environmental degradation. This was said by Supreme Court in the same case. And Indian Supreme Court has also adapted precautionary principle, but in a modern form. The principle has been followed in many cases, and the court has declared it as an essence of Article 21 of the Constitution of India. It was said again in the same case, MC Mehta versus Union of India, and this case was Bhadkal and Surajkund Lake matter. The court adopting the principle explained that this principle has led to the special principle of burden of proof in environmental cases, where burden as to the absence of injurious effect of the actions postponed in placed on those who want to change the status quo. The person who want to maintain the status quo by maintaining a less polluted state should not carry the burden of proof, and the party who wants to alter it by carrying on some activity must bear this burden. In case insufficient proof is presented, the presumption of the court will operate in favor of environmental protection, and the activity would not be allowed to operate or continue to operate. In MC Mehta versus Union of India, the precautionary principle, what this is what Supreme Court said in its judgment. The precautionary principle has been accepted as a part of the law of land. Article 21, 47, 48A, and 51 AG of the Constitution of India give a clear mandate to the state to protect and improve the environment and to safeguard the forest and wildlife of the country. It is the duty of every citizen of India to protect and improve the natural environment, including forests, lakes, rivers, and wildlife, and to have compassion for living creatures. The precautionary principle makes it mandatory for the state government to anticipate, prevent, and attack the cause of environmental degradation. In this light, we have no hesitation in holding that in order to protect the elephant population in Shugur Plateau region, it was necessary and appropriate for the state government to limit commercial activity in the area falling within the elephant corridor. Supreme Court has explained this principle in detail in Vellore Citizen Forum versus Union of India. So what are the key facts of Vellore Citizen Forum? In Vellore Citizen Forum, there is a city in Tamil Nadu known as Vellore. And in Vellore, there are several tanneries that manufacture leather products. And because of these tanneries that are working there, the water of River Pala that goes through Vellore city, it was found to be highly acidic. And all the tanneries were closed by the order of the court. Okay. And then what this court said about precautionary principle in this case is that the precautionary principle in the court in the context of municipal law means environmental measures by the state government and statutory authorities must anticipate, prevent, and attack the cause of environmental degradation. Second, where there are threats of serious and irreversible damage, lack of scientific certainty should not be used as a reason for postponing measures to prevent environmental degradation. The onus of proof is on the actor or the developer industrialist to show that his action is environmentally benign. In the view of the above mentioned constitutional and statutory provisions, we have no hesitation in holding that precautionary principle and the polluter pay principle are part of environmental law of the country. So we will discuss how the implementation is done of this principle in India. In India, polluter pay principle was first applied in the case of Indian Council of Environmental Action versus Union of India. In this case, Justice Dalveer Bhandari stated that reversing the imbalance caused to the environment is an offset of industrial process. Hence, the financial responsibility cannot be shifted to the shoulders of the government, neither for preventing pollution nor for correcting the dents. In case of Andhra Pradesh Control Board versus Professor M.V. Naidu and others, the scope of implementation was further increased. The courts enabled the tribunals and environmental organizations to apply these principles when cases are registered to the tribunal or organizations. The applicability of the principle for the National Green Tribunal is explicitly mentioned in Section 20 of National Green Tribunal Act. So there's the Section 20 of National Green Tribunal Act give powers to the National Green Tribunal to apply the precautionary principle, polluters pay principle, and public trust doctrine and sustainable doctrine of sustainable development to decide the cases that come before National Green Tribunal. So Section 20 clearly gives mandate to National Green Tribunal to apply these principles. Now the second principle, that is, it is polluters pay principle that we are going to discuss today. The polluter's pay principle essentially holds the polluter liable for pollution caused to the environment. The polluter is liable for every damage caused to the environment. So according to the Polluter Pays Principle, the polluter has to not only compensate the victim of pollution, but also compensate for the restoration of environmental degradation caused under 1972 and 1974 OECD recommendations. The measures to be taken by polluters for controlling the pollution is decided by public authorities so that the environment is in an acceptable state post the industrial operation. Therefore, the polluters bears the cost of health hazards caused to the public as well as the cost of restoration of the environment. In other words, the cost of measures should reflect on the cost of goods and services, the production and or the consumption of which led to pollution. The polluter pay principle was first introduced by Organization of Economic Cooperation and Development, OECD, 1972. The polluter pay principle can be applied only where it is proved that some damage has been caused to the man and material or to the environment by industrial unit by their activity. Mere violation of legal provisions laying down the standard does not attract this principle. Supreme Court in Research Foundation for Science versus Union of India held that this principle envisages precautionary protection against environmental hazard by avoiding or reducing environmental risk before specific harm is expected. Thus, it has become a part of the principle of sustainable development. In Indian Council for Environment Legal Action versus Union of India, the polluters pay principle was explained as under. Once the activity carried on is hazardous or inherently dangerous, the person carrying on in such activity is liable to make good the loss caused to any other person by his activity, irrespective of the fact whether he took reasonable care while carrying on his activity. The pollution industry is absolutely liable to compensate for harm caused to the environment. He is also liable to pay the cost of restoring the environmental degradation, reversing the damaged ecology. This principle means the absolute liability for harm to the environment. Thus, it became a principle of remediation of damaged environment as a part of the process of sustainable development. Mehta Kant Enclaves Matter versus Union of India. So this is another MC Mehta case. The court ordered for the demolition of constructed houses on the forest as well as asked the developer to deposit 5 crores for the rehabilitation of the damaged area as the forest land was allotted to for non-forest purposes. The developer Kent Enclaves matter was also asked by it was also decided by applying the polluter pays principle to pay the full refund to investors along with the interest of 18% per annum from the cost of investment and cost of construction thereon. It was directed that the cost of construction be paid in equal proportion by our content cooperative developers and town and county planning development of the state of Haryana. So what happened in this case? There some development permissions were given to Kent developers, and so the permission was to build a film city. But instead of building a film city, they developed a residential colony. So all the residential colony was demolished, and the by applying the polluter pays principle, hefty fines were placed on the developers to demolish the illegally built colonies and to make good for the restoration of environment. The next principle that we will discuss today is public trust doctrine. The public trust doctrine precisely rests on the principle that certain resources like air, sea, water, and the forest have such a great importance to the people as a whole that it would be wholly unjustified to make them a subject of private ownership. The said resources being a gift of nature, they should be made freely available to everyone irrespective of their status in life. The doctrine enjoins upon government to protect the resources for the enjoyment of public for the enjoyment of general public rather than to permit their use for private ownership or commercial purposes. This doctrine has its origin in Justinian Institute of Romans, later on adopted by English common law. Magna Carta of 1115, which its change introduced in 1641 and 1647, declared that public trust doctrine was a part of the established law. They declare that the government has an affirmative duty to administer, protect, manage, and conserve fish and wildlife. The doctrine also the doctrine has also been acknowledged by French Civil Code and Spanish Civil Code as a concept of property. Supreme Court in MC Mehta versus Kamalnath declared in unequivocal terms, our legal system based on English common law includes the public trust doctrine as a part of jurisprudence. The state is the trustee of all national resources, which are by nature meant for public use and enjoyment. Public at large is the beneficiary of the seashores, running water, airs, forests, and ecologically fragile lands. The state as a trustee is under a legal duty to protect the natural resources. These resources meant for public use cannot be converted into private ownership. And Shagir Ahmad Justice also reiterated that public trust doctrine is a part of law of the land. Justice G.S. Singhvi has explained in Center for Public Interest Litigation versus Union of India that natural resources belong to the people, but the state generally owns them on behalf of its people. And from that point of view, natural resources are considered as national assets, more so because the state benefits immensely from their value. While distributing natural resources, the state is bound to act in accordance with the principle of equality and public trust. This case is popularly known as radio spectrum or 2G spectrum case. Court held that airwave spectrum is a natural resource and the state, as a legal owner of these natural resources and as a trustee of the people, has power to distribute them. But the process of distribution must be guided by constitutional principles, including the doctrine of equality and larger public good. Arijit Pasaya justice while describing that by destroying the natural environment, man is committing matricide, having in a way killed Mother Earth, declared in T. N. Godavarma versus Union of India. Our legal system based on English common law includes the public trust doctrine as a part of its jurisprudence. The state is the trustee of all natural resources which are by nature meant for public use and enjoyment. The public at large is the beneficiary of all the seashores, running water, air, forests, and ecologically fragile land. The state as trustee is under a legal duty to protect the natural resources. These resources meant for public use cannot be converted into private ownership. The aesthetic use and the pristine glory cannot be permitted to be eroded by private, commercial, or any other use unless the court find it necessary in good faith for public good and in public interest to encroach upon the said resources. In T. Damodar Rao versus Municipal Corporation of Hyderabad, the court made it clear that protection of the environment is not the only duty of citizen, but it is the obligation of the state and all other state organs, including court. Therefore, the court must be able to apply these considerations and take decisions in environmental pollution cases. So this is the end of our video lecture. Thank you.